Thank you. It's a great pleasure to be here. I want to thank the Journal of Law and Technology and Jonathan Zittrand for combining to set things up for me in this delightful way. It is true that I feel somewhat overwhelmed at the prospect of trying to talk for any substantial length of time about a lawsuit that isn't going anywhere very much. I am, however, going to mention the SCO lawsuit from time to time in my remarks. Mr. McBride, when he was here, was kind enough to mention me once or twice, and I'm going to do him the same favor. I hope you will feel, those of you who followed the conversation, that I'm responsive to his remarks, though I don't think that doing it in the form of he said, I say, would lead, as Jonathan suggests, to a particularly intellectually challenging evening. Free software, you will know, I'm sure, that I didn't make this up, is free as in freedom, not free as in beer. One of the primary problems with the conversation we have been having about this lawsuit in your Distinguished Speaker series this year is that, at least so far, it had apparently been suggested that the goal of those of us who believe in the free software movement was primarily to prevent people from earning a profit in the computer industry. This results, it is sometimes suggested, from some wild antipathy to the idea of economic benefit or some particular antipathy to the idea that people ought to have incentives to do what they do. I shall along the way suggest that we believe very strongly in incentives, though we see the problem of incentive perhaps a little bit differently than Mr. McBride. But it isn't, after all, and we need to begin there, it isn't, after all, about making things free as in beer. It is about making things free as in freedom. The goal of the free software movement is to enable people to understand, to learn from, to improve, to adapt, and to share the technology that increasingly runs every human life. The fundamental belief in fairness here is not that it is fair that things should be free. It is that it is fair that we should be free and that our thoughts should be free. That we should be able to know as much about the world in which we live as possible, and that we should be as little as possible captive to other people's knowledge beyond the appeal to our own understanding and initiative. This idea lay behind my dear friend and colleague Richard Stallman's intense desire, beginning in the early 1980s, to bring about a world in which all the computer software needed by anybody to do anything would be available on terms which permitted free access to the knowledge that that software contained, and a free opportunity to make more knowledge and to improve on the existing technology by modification and sharing. This is a desire for a free evolution of technical knowledge, a descent by modification untrammeled by principles that forbid improvement, access, and sharing. If you think about it, it sounds rather like a commitment to encourage the diffusion of science and the useful arts by promoting access to knowledge. In short, the idea of the free software movement is neither hostile to nor in any sense at cross purposes with the 18th century ambition for the improvement of society and the human being through access to knowledge. The Copyrights Clause in Article 1, Section 8 is only one of the many ways in which those rather less realistic than usually pictured founding parents of ours participated in the great 18th century belief in the perfectibility of the world and of human life. The Copyrights Clause is an particular legal embrace of the idea of perfectibility through access to and the sharing of knowledge. We, however, the 21st century inheritors of that promise, live in a world in which there is some doubt as to whether property principles, strongly enforced, with their inevitable corollary of exclusion, this is mine, you cannot have it unless you pay me, whether property principles best further that shared goal of the perfectibility of human life and society based around access to knowledge. Our position has been for 20 years that to the extent that existing copyright rules encouraged the diffusion of science and the useful arts, they were good. And to the extent that they discouraged the diffusion of knowledge and the useful arts, that they could be improved. We have, pardon me for taking credit for something, we have improved them substantially. Not by negating any of the existing rules of copyright. On the contrary, we have been quite scrupulous about that. One of the things which amuses me amidst the rhetoric that is now being thrown around is how oddly orthodox I seem to me when I consider my weekly activities as a lawyer. Though not necessarily welcome in Los Angeles, I find myself behaving very much like an awful lot of lawyers in Los Angeles. I want my clients' copyrights respected, and I spend a fairly large amount of tedious time trying to get people to play by the very rules embodied in the Copyright Act that I am supposedly so busy trying to destroy. Free software is an attempt to use the 18th century principles for the encouragement of the diffusion of knowledge to transform the technical environment of human beings. And as Jonathan says, my own personal opinion on the subject is that the early going in our experiment has worked out pretty well. It is because it has worked out pretty well that there is blowback from it. And one of the little pieces of that blowback is the controversy now roiling the world entitled SCO against IBM, which apparently is supposed to become, Mr. McBride said it when he was here, SCO against something called the Linux community. I don't think that's actually what's happening, but it is certainly what Mr. McBride came here to say was happening.